this is something I want to ask you about, because a lot of the conversation around equal and shared parenting talks about what type of discretion do we want to remove from the judges? Well, in the state of Texas with the SPO, in a sense, you've gotten rid of a lot of that discretion in the initial order. Like, hey, you took primary parental responsibility, and you were the one that was out of the home working. So here's the standard parenting order.
Sure.
So do you think going further down that road and removing even more discretion is in the best interest of our children, of our next generation? Or do you think allowing that discretion and allowing a judge to customize what's going to happen is what's best?
Okay, so let's be really fair about that. I mean, how much time, and you practice too, Mark, right? I mean, how much time do you think that a judge actually listens to your case? And how much internalization does that judge do? And how do they really know? Because everybody is going into the courtroom and they're like, okay, well, this is my best foot forward, right? I mean, that's what they're going to show. They're not going to really show a day in the life of this child. They're not going to do that because, you've got, as well as I do, you have 3 to 4 hours or maybe a day or maybe 2 days or maybe 3 days to present your case. And then the next thing you know, you really can't get everything before that court. And so for me, less discretion on the part of the judges would be the best thing to do. It really would be. And I always counsel my clients when they come in, look, is there a way? That's the first question I ask. Is there a way to mitigate? Is there a way to try to figure out a way that would be in the best interest of this child? And, unfortunately, most of my clients, they listen to that. And I think that the judges that, when you really think about how much time you have in front of the judge and how much time you have to present your case and what you can present and how, the rules of evidence, all of the stuff that, that precludes you from being able to present really what's real. It makes it a very difficult situation. So for me, in my practice, it's like, let's try to stay away from the courtroom because it polarizes the parents. It doesn't help with co-parenting at all. Let's be fair.
Yeah.
It just doesn't. And, if we can get them on the same page, it makes a complete different situation. Now, that being said, it's very difficult to get them on the same page some of the time. And the courts, I'm the first person to say, let's try to keep away from the courts because you lose control when you do that. You just do.
Yep.
You just do.
Yeah, that's the exact same thing I tell clients. I don't know how many times I represent exclusively fathers, or about 80 to 90% of my clients are fathers, 100% men. And I would probably say 50% of my clients walk in, and one of the first things they say is like, "Are you a bulldog attorney? Are you going to go fight for me?" And I'm like, "You probably don't want that. You don't want to make this a 3-year nasty back and forth battle. When what we should be trying to do is, even if you aren't seeing eye to eye with your co-parent right now, if you aren't seeing eye to eye with her right now, you guys are still going to be in the best position to make the decision of what's best for your child and for you guys. When you're going to see a judge in California, you may see a judge once every 3 months for a year and a half, and then you have a 6-hour trial. They have no idea who you are. We've been, and I don't know if you guys are still telephonic or virtual in a lot of areas. You guys are back in person, but
no. We are. Some of the outlying counties are doing the same thing. I don't want to get you off your, because the point you're making is super important, I think. Personally.
Yeah, no, it's one of those things where, like, you think about, for the last 2 years, we've been on the telephone in some counties. Judges haven't seen anybody. How can a judge get a true feel when they may have 60 to 80 cases on their docket any given week, and your attorney's gonna talk on the phone for 5 to 25 minutes, and the judge is going to make a decision. Even when it was in person, even when you involve mandatory mediation, there's not enough bandwidth. Judges are humans. Attorneys are humans. There's no way for them to take in all the relevant information. So they're kind of aiming and shooting blind, where even if parents don't agree, we need to find all the common ground that there possibly could be and narrowly tailor what the judge is actually going to decide.
Okay, I could not agree with you more on that situation. I just couldn't. And being in a situation where you're on the telephone, or you're talking with the judge, that's, that you're not in person, it kind of, in my opinion, it hurts the case a little bit. You don't get to see the tonal quality of their, you can see the tonal quality. You don't get to see them, in person. You don't feel the energy. It's just not a really good situation to be on the phone or in Zoom. To me, I would prefer to be in person.
Yeah, no, that's definitely out here. We've over the last couple of months gotten back in person for most of the regular hearings, and I'll say this: I'm the biggest fan of that, because getting face to face with opposing counsel, knowing you're going to walk into a courtroom 15 minutes from now, a lot of times spurs action. A lot of times clients think it's going to be some nasty litigated out hearing. Exactly. And then we end up having to tell the judge, go in, check in, say, hey, give us another half hour. And we end up writing out a stipulated agreement where both parents got to put their input, and they ended up getting most of what they wanted. They realized there was common ground.
Don't you think that's a win-win for the kids?
So much. Think about it. I'm sure we have viewers here who have been in the court system for 4, 5, 6, 7 years. And I'll say the longer you're in the court system, the more jaded you get, and the more clashing that can occur between co-parents. If you have two attorneys who are willing to, I call it laying on their clients, like when the other side's asking for something reasonable and they're just being difficult to be difficult, where you grab them by the shirt collar and say, like, stop it, cut it out. You don't even care about this, or this is exactly what you want. You're just disagreeing to disagree. You can turn what could end up as a several year process and 16, 18 years of difficulty into a 6 or 8 week process. And then kind of that healing can begin.
Absolutely. I completely agree with that.
So
and it's 9 times out of 10. Don't you think, Mark, that 9 times out of 10, we're able to work it out. If we're in a courtroom, we just ask the court to, let us have some time to just talk.
Yeah, 100%. I've had so many. I think it happens more often than not. You go in, and obviously attorneys are busy, and it's hard to maybe get on the phone with them for a prolonged period of time. But you show up and you see them in the hallway. Hey, you want to chat? You start talking, and it's like there is a lot of common ground.
Sure.
It becomes very real for the parties too when there's the big wooden door swinging open and closed in front of them, and they don't know what to expect. So. Right. I think if more attorneys were less worried, and I think it's becoming more and more common, if more attorneys were willing to say, hey, we're going to make a deal or we're going to negotiate an agreement between the parties that work for both of them and are in the best interest of the child, rather than going in front of this judge whose courtroom is underfunded, understaffed, and overburdened with caseload.
And that's what's happening on every front. Honestly,